All right, we're at a temporary plateau, and it is 2 p.m., so I will start. Welcome. I am David Randall, Director of Research at the National Association of Scholars, moderator for the day, and I am delighted to welcome people to the first of our webinars on race in higher education. Our particular webinar today, the inaugural one, a referendum on race, SFFA versus Harvard, and the court's role. Now, I am delighted to have three distinguished speakers, and I'm going to give abbreviated versions of their CVs, which may appear in the chat button below at a later point. In alphabetical order by last name, Dennis Saffran is an appellate attorney and political and public policy writer and consultant based in Queens, New York. He has served as chief of appellate litigation for Nassau County, chief lawyer of the New York State Division of Housing, and has litigated constitutional and municipal law cases in the Second Circuit Court of Appeals, the New York State Court of Appeals, and other appellate courts. Richard Sander is an economist and law professor at UCLA, where he has taught since 1989 and where he serves as director of the UCLA Rand Center for Law and Public Policy. Amongst his notable publications, Moving Toward Integration came out in 2018, and Mismatch came out in 2012. And third is Willliam E. Trachman, General Counsel for Mountain States Legal Foundation, where he protects the rights of individuals to live freely and securely under the U.S. Constitution. He has served in the Department of Education as Deputy Assistant Secretary in the Office for Civil Rights, also General Counsel to the Douglas County School District, and co-chair of the Colorado Federalist Society. Now, as I say, they are both very distinct, all three very distinguished. And more in their CVs, as I say, ought to appear in our chat and Q&A buttons. Chat and Q&A buttons leads me to the format of how things work. It will be 12 to 14-minute talks apiece. The order will be Dennis, Will, and Rick. Then there will be questions and answers, ideally done by you, the audience. You will put in your questions, comments into chat and Q&A. I will be glad to relay them onward. The participants can also read them, talk to each other conversationally. If your questions don't get answered, don't worry. Email them to me, randall@nas.org, RANDALL, @nas.org, and I'll be delighted to forward your questions afterwards to our participants so that they can have the option to respond to you. Also, don't worry if you have to leave halfway through. This is being recorded and will be available on the National Association of Scholars YouTube website within 24 hours. I believe that everyone will get an email who is signed up to attend this, giving the precise link, but you can also simply Google search National Association of Scholars YouTube. You can see this in perpetuity if you have to leave, and you can show it to your friends and family, and should. Having said all that, I'm delighted to ask first, Dennis, would you be so kind as to give the first talk?
Sure. Thank you very much, David. So I've been tasked with giving a hopefully brief overview of the four major previous cases that led up to the SFFA versus Harvard and UNC cases that were recently heard by the Supreme Court. So I'll try to keep it from being too dry, but the basic legal history is this. The first of those four cases, I'm sure you're all familiar with, was the Bakke decision in 1978. That involved a specific set-aside for minority applicants to the UC Davis Medical School. And it was a total of 16 out of 100 places in each class were limited to minorities, Blacks and Latinos, maybe a few others only. And so it was effectively a separate admissions program. Whites competed for 84 slots and others competed for 16 slots. That was struck down by the court. Bakke was actually an anti-affirmative action decision in all but one way, in all but one key way. It was struck down 5-4, but the vote was really 4-1-4 for conservatives, then led by Justice Stevens, who would go on to be one of the court's leading liberals, for liberals, and the key swing opinion by Justice Powell. And what Justice Powell held was that, first of all, that reverse discrimination, as it was known, against the majority is subject to strict scrutiny. That was a major subject of debate, whether strict scrutiny only applied to discrimination against so-called discrete and insular minorities, such as African Americans. Justice Powell sided with the conservatives on that and said any discrimination based on race, whether it's against whites, blacks, or what have you, is subject to strict scrutiny. The other key issue that had been fought about for years and years in society, where he sided with the conservatives on the court, was that reversing past discrimination against a particular minority, such as African Americans, which of course had always been argued as the primary justification for affirmative action, and is still ironically argued that way 44 years after Bakke. But Justice Powell sided with the conservatives to rule that that is not a compelling state interest justifying racial preferences, except in the small handful of cases where there had been a specific judicial or administrative finding that the particular defendant in the case had engaged in discrimination. But just past societal discrimination, or even if that defendant admits, oh, of course we discriminated against blacks, that is not sufficient. He went on to hold that quotas, i.e. any specified percentages or racial balancing, is facially unconstitutional. So on all those key, what were thought to be key issues in the case, he lined up with conservatives. But he then ruled that the, quote, educational benefits of a diverse student body is a compelling interest justifying the otherwise illegal use of race in admissions. And what's key for the present case is he cited and attached the Harvard program. Harvard had been part of an amicus brief submitted by all the elite, a bunch of elite schools, and had attached as an appendix its own admissions system, whereby supposedly race was just a, quote, plus factor. As they said, it was like being a farm boy from Idaho or a violinist, and it's allegedly not a quota. And Justice Powell held that out as the model of acceptable racial preferences. So by 5-4, UC Davis Med School was forced to admit Alan Bakke, but all other affirmative action was struck down except for diversity. Now, for 25 years, it wasn't clear if Powell's opinion was controlling, and I won't get into the legal weeds on that because I don't really understand it very well myself. Some law professors on here probably would understand it better than me, but the legal weeds about when a swing opinion like that is actually precedential and when it isn't. Most courts held that it was, some dissented. In any event, the court gets to the, takes up the issue again 25 years later in a duad of decisions, the Grutter and Gratz cases against the University of Michigan in 2003. It was a split decision. Gratz actually struck down the affirmative action program for the undergraduate college. That was a strict point system. You got, if you were a so-called underrepresented minority, you got 20 points of 150 on their scale. And that was 20 points of 100 you needed to get in. So any Black or Latino student started out 1/5 of the way there. Court struck that down 6-3. But the Grutter case was against the Michigan Law School, which had a more so-called holistic review, didn't use specific numbers. And the court upheld that holistic review by 5-4 with the two swing votes who struck down the Gratz program but upheld the Grutter program were Justice O'Connor, who wrote the majority opinion, and Justice Breyer. And in Grutter, 4 key points. First of all, the court formally adopts the Powell opinion, so that now, 25 years later, there's no more dispute. That is the law. They hold that diversity is a compelling interest, but racial balancing is patently unconstitutional. Like Justice Powell, Justice O'Connor again cites the Harvard program approvingly as the model of good affirmative action. And she says that race can be a plus factor. So quotas are bad, she reiterates, but goals are okay. What does that mean? Justice Souter, who was by then had become part of the liberal faction that would have upheld both Grutter and Gratz, had a very telling line in his dissent in Gratz. He says, you're striking this down because it has a number, because it gives you 20 points. But how is that different than what you just upheld in Grutter? You say race can be a plus factor. Well, usually when you have a plus sign, what comes after it? It's a number. It's just that the undergraduate college is being honest about what they're doing, and the law school is dissembling, but there's no difference. He would have upheld them both. But he made a good point about it being, it really being a distinction without a difference. Finally, in Grutter, most memorably, Justice O'Connor says at the end of her decision, quote, "We expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today." Now, note those last few words and note the contradiction. People talk, that's really language that goes to redressing past discrimination, which Powell had held 25 years before, and she had just affirmed and given the imprimatur of the court that that's not a justification for racial preferences. If the only justification is diversity, when would that ever stop being a compelling interest? Why in 25 years? Won't you always want a diverse student body? And it's almost like she got to the end of the sentence and she and her clerk realized it and didn't know what to write. What flows for the end of that sentence is will no longer be necessary to redress discrimination. Instead, they just came up lamely with to redress the interest approved today. Okay, next case. Next two cases are the Fisher cases in 2013 and 2016. Fisher 1 decided in 2013. This involved Abigail Fisher, who was applying to the University of Texas. Not under the, she didn't get in under the 10% set aside, which you all may be familiar with, that George W. Bush, as governor, had implemented in response to a decision actually striking down affirmative action in Texas and saying that Powell's opinion wasn't controlling. They come up with a 10% set aside for the top 10% graduates in all classes. Fisher wasn't in the 10%, but then in the wake of Grutter, Texas said, well, in addition to setting aside 10%, which had been working just fine, minority enrollment had increased at all University of Texas outlets, including the flagship in Austin. In addition, we're going to have a so-called holistic program, just like Harvard. So we're going to give a double bonus to minority applicants. Fisher doesn't get in under the 10%. She doesn't get in compared to less qualified minority applicants because they reinstituted the so-called holistic program. And the court rules 7-1 essentially for her. They remand, but they reverse and remand decisions they've been against her at the lower level. And the main holding was that any reviewing court must be satisfied that there are no workable race-neutral alternatives before it approves the use of racial preferences to achieve diversity. If you can achieve it any other way, then you can't use race. They say that's a, quote, searching inquiry, and that a reviewing court can't accept the school's assertions or presume it acted in good faith. And it was that you can note the tone of that. It's not just the holdings, but the tone of the whole opinion, which was written by Justice Kennedy. I should have noted. The whole thing suggested that affirmative action was really on the ropes. I mean, Kennedy even went out of his way to question whether diversity is a compelling interest at all, which the plaintiffs hadn't raised. And he cites in saying it's subject to strict scrutiny and sending it back to the lower courts to apply. He quotes Justice Powell's famous line that strict scrutiny can't just be strict in theory, but feeble in fact, that strict means strict. So everyone thought this was the next to final death knell for racial preferences. With that, the plaintiffs here in the current cases filed the Harvard and UNC cases in 2014, the year after Fisher won. And then in 2016, Fisher comes back, Fisher 2. It went back to the circuit court. They ruled against Fisher. Circuit court doesn't send it back down to the district court for more fact finding in line with the new guidelines from the Supreme Court. They rule again on the same record that Fisher had no case, goes back up on the very same record to the Supreme Court. Justice Kennedy again writes the decision. This time comes down on the other side. Fisher too left the law totally confused. I won't pretend to know what it means because I've read it over several times and I have no idea. Kennedy reiterates that the university bears the burden of proving there are no workable race-neutral alternatives. So in that respect, he echoes Fisher 1. But he finds that these race-neutral alternatives that were proposed there, such as enhancing the 10% set aside or having class-based affirmative action, were not workable. He doesn't really explain why. He says, quote, the educational benefits of diversity writ large are not a sufficient compelling interest. He does say that the goals can't be illusory or amorphous. They must be sufficiently measurable, but they can't be numerical or that would be a quota. He still says quotas are not good. So that was how we were left as the Harvard and UNC cases were starting to percolate up. How are we doing on time? Do I have a few more minutes or just to make some points about Harvard and UNC, or should that wait for questions?
I'd say we have done 15 minutes. Let me just
okay.
I guess, ask you to defer to the Q&A.
Sure.
For continuation. Okay. All right. Look, thank you so much. We will continue on that particular subject. And we are going next to, I look at this, Will. Will, would you be so kind as to go next?
Absolutely. Thanks, David. Greetings from flyover country, folks. I'm out in Colorado at Mountain States Legal Foundation. We're a 501c3 in Lakewood that does constitutional litigation. I have the honor of serving here. I left the Trump administration on January 20th of 2021 after having served in three years in the DeVos Department of Education, as senior counsel and deputy assistant secretary for civil rights in the Office for Civil Rights. And that's relevant here because the amicus brief that Mountain States filed in the Harvard and UNC case was on behalf of myself and my former colleagues, including the Assistant Secretary for Civil Rights. We filed with the Supreme Court both at the petition stage and then on the merit stage in order to talk through our experience in the real world dealing with how schools, school districts, and of course, colleges use race. And the use of race is not shrinking. It isn't as though schools are paying heed to the cases that Dennis talked about and saying, well, that 25-year deadline, that's coming up soon. We better wean ourselves off of racial preferences. Instead, the use of race is increasing. And in the last few years, it's been increasing exponentially. And so our brief wanted to identify and highlight those themes and talk about why initially the court ought to take the case. And now that the court has the case, why they ought to rule really broadly to cover things like segregated graduation, segregated housing, segregated classrooms, segregated grading, all of those things that we saw during our time in the Office for Civil Rights. So before I go further, let me take a step back. I'm going to discuss the oral argument and what occurred and the themes of our amicus brief. But I first wanted to address, what does OCR do? Our tenure in OCR with regard to race was enforcing Title VI. Title VI is a 1964 statute that's part of the Civil Rights Act that says that recipients of federal aid can't discriminate on the basis of race. And courts have traditionally said, we are going to interpret that ban on race discrimination to not be more of a ban than the Equal Protection Clause. So you have both UNC, which is bound by the Equal Protection Clause, and Harvard, which is a private school and is not bound by the Equal Protection Clause, nevertheless bound by Title VI. So those two schools come into their case bound by essentially the same case law, saying that what Dennis articulated is, as long as we have a diversity interest at play, we are allowed to achieve that diversity interest in a narrowly tailored way. So it's a plus factor, not a quota. We've considered race-neutral alternatives. We periodically review our program and decided that race is an essential factor of achieving diversity, and we're going to do it. So that is something that a lot of schools across the country are doing and doing more and more and more. As Dennis mentioned, the Students for Fair Admission cases were brought in 2014, and as you can see, the 25-year deadline mentioned in Grutter, which was issued in 2003, has not gotten there yet. Our amicus brief dealt with that by saying, look, if you filed another case today that doesn't get resolved for another 7 years, you'd be past the deadline. So now is the time to resolve these issues. Well, what happened in the Trump administration in OCR? One thing that happened is that we repealed a lot of Obama-era guidance that had been based on the cases that Dennis just articulated. So after the first Fisher decision, the Obama administration took a victory lap and said, look, diversity is just fine. The Supreme Court has blessed the idea that Grutter remains alive and can be used as a way of implementing a diversity program. And by the way, diversity is really important, and you ought to embrace it and do more and follow the Fisher framework in order to achieve it. Then after Fisher 2, they took another victory lap and issued more guidance, saying now we have clear evidence from the Supreme Court that schools can implement diversity programs broadly as long as they're complying with strict scrutiny. Don't be worried about what the court has said in Gratz or Bakke. And even before that, they'd issued guidance saying, look, if you want to be a little bit clever about things, if you want to use proxies for race, like zip codes, for instance, as a way of achieving racial diversity, that's fine. Dennis alluded to the idea of whether Supreme Court opinions are precedential or not. What the Obama era OCR did was they counted heads in a case called Parents Involved, where you had 4 dissenting justices and a concurrence by Justice Kennedy saying that I might be open to using these proxies for race. And they said, there you go, there's 5 justices right there. You've got 4 dissenters and a concurring opinion by Justice Kennedy. That's a majority. So go for it. If you want to use proxies for race as a way of getting at race, that's fine. as long as you aren't doing it to benefit majority races. As long as you're achieving racial diversity in a positive, benign way, that's fine. Of course, that's not generally how the Supreme Court thinks of using race and engaging in race discrimination. So we repealed all that prior guidance when we were in OCR. We issued new guidance in the form of webinars toward the tail end of our administration, saying things like it violates Title VI to affirmatively engage in race discrimination, like segregating classrooms for the purpose of lesson plans, segregating grading for the purpose of grading students differently on the basis of race, and segregating housing. And within a few weeks of the administration changing, the Biden administration withdrew all of that guidance, saying it was contrary to equity. And an executive order that the President Biden issued very early on in his tenure. And we wanted to highlight all of those things in our amicus brief to say, look how the Civil Rights Office within the Department of Education vacillates back and forth. And this is ambiguity that you're causing schools, school districts, educators, students across the country to have to worry about. So on the one hand, you might have a Republican administration that says one thing about race, and then you might have a Democratic administration repealing what we thought was pretty obvious guidance toward the public that you ought not segregate your classroom. Most people thought that issue was resolved in 1954, but the Biden administration thought, no, that guidance is contrary to equity. So what happened after we filed the amicus brief? The Supreme Court granted certiorari, which means they will hear the case. That was early in 2022. And they combined two cases, the UNC case, which actually had not gotten a ruling from the appellate court yet. They granted certiorari before judgment, and they granted certiorari in the Harvard case, of course. Combined the cases initially, then unwound that combination because Justice Jackson, the newest justice, is conflicted out of the Harvard case. She was on the Harvard Board of Governors, I believe, fairly recently, and committed to recusing herself when she was going through confirmation. So now you had Justice Jackson hearing the UNC case, but then not the Harvard case. In our brief, as I touched on, we included a couple themes. One is that there's a lot of ambiguity in the law, that the issue of proxies and whether you can use zip codes or other ways of getting at race is one that the court ought to resolve, especially given that disparity between whether you can use proxies for good things but not bad things. If you adopt a proxy like an employment test that you want to discriminate against minorities in employment, usually that's illegal. So to say that it's okay as long as you're achieving racial diversity is a little bit of a quirky result that the department initially articulated. And we also urged the court to issue a broad ruling that it would encompass not just racial discrimination through the use of preferences in admission, but that would cover things like segregating classrooms and graduations and dorms. I had oral argument in the case, which occurred on October 31st. It was long. It's about 5 hours long, surprising to some of us because we weren't intending to spend our entire day listening to oral arguments, but it was a very vibrant discussion. Justice Barrett, in particular, echoed many of the themes that myself and my colleagues submitted in our amicus briefs, saying, look, whatever rule you adopt in this context in race and diversity might be adopted in housing, in classrooms. So we were encouraged by that. And affinity groups was what Justice Barrett tacked on to as well. One of the best lines in the oral argument actually came from the Chief Justice Roberts, who occasionally can be more of a centrist, can occasionally side with the justices appointed by Democrats, when the Harvard attorney Seth Waxman said, look, this is not that big of a preference. It's essentially what you would get if you were a really talented oboe player. Chief Justice Roberts intervened very forcefully and said, we did not fight a civil war over oboe players. And it sort of took Seth Waxman aback because of how strong and strident Chief Justice Roberts was. People are, of course, reading tea leaves based on those sorts of statements in oral argument. You never know what's going to happen. Elizabeth Prelogar, who is the Solicitor General, argued for the United States. I thought she was very forceful in terms of saying that we need to include racial preferences for diversity in the military. So, do with that what you will. It's hard to know whether the justices will carve out military academies or the military itself when determining what to do with racial preferences. That was certainly one topic at oral argument. Another was what to do about the categories, the racial buckets that schools use. There's a very persuasive amicus brief filed by a law professor named David Bernstein, who pointed out that 60% of the world's population is Asian. And so if an Asian student is applying, that can include people from China, from Pakistan, from any number of places that are very disparate in terms of their culture and what they would actually lend to a student body environment. If you were genuinely trying to link race and diversity and avoiding groupthink and creating better outcomes, it's strange to say we can group people by skin color and achieve the same thing when those buckets are so large. Now, that's one thing that we definitely saw when we were at OCR, is that Asian American groups are now alleging that race discrimination and preferences in post-secondary education, that they actually are being harmed more than whites. And so some of the charts in the case, and I'm sure Rick will address many of these issues, demonstrate that whites have a racial preference as compared to Asian Americans, which you would think, with all the rhetoric going around, that would be a truly stunning fact. And so I think that justices picked up on that in oral argument. The last thing that our brief and that the court was really concerned about was the stare decisis issue. As Dennis pointed out, you have case after case after case indicating the use of skin color and race is not per se prohibited, that schools can go ahead and consider race in some ways. And so what do we do about all of these cases that have told schools to go ahead and rely on these cases? And in the same vein, what do we do about that 25-year deadline, which technically is not up? Should we write an opinion saying, okay, you can use race until 2028 and then no more? Should we write an opinion saying that diversity, racial diversity, is not a compelling interest anymore, or that it never was and all those cases were wrong? Should we write a case saying that, or an opinion saying that that's that doesn't really matter what race your student body is? And there was some, I think, reluctance on the part of the advocates to say that race never matters. Certainly many justices asked about a college that says, well, we want to ask you to talk about your challenges in life. And one of those challenges may be that you overcame race discrimination. Is that okay? The advocates were certainly fine with that. But then when it came to other proxies, like what about the descendants of slaves? We want to give a preference to that. That was a question by Justice Kavanaugh. It was hard to answer that question because that is a proxy that is very closely related to race. In our brief, we talked about workability and that these cases, regardless of what they've said or what schools are relying on, are very challenging to actually use as workable decisions, and that the court ought to intervene and say, look, we have said a lot of things. What's happening, in our opinions, is not being reflected on the ground. Schools are increasing the use of race. They're expanding the number of contexts in which they use race. And that ought to be cause for concern, that our precedents previously are not workable. And that's one of the things that courts consider when they decide whether to overturn or not previous precedents. So the oral argument was, I think if you were reading tea leaves, you would say that Harvard and UNC are facing a challenging circumstance, that we will see something by next June, either getting rid of racial preferences in education, or at least saying something new that schools will have to pay attention to in terms of how to go forward. Clearly, the Chief Justice's comment about oboe players, I think, was indicative of his mindset and the mindset that he had in a prior case, that the way to end discrimination on the basis of race is to stop discriminating on the basis of race. So I'm happy to answer your questions, but before I do that, I'm going to turn it over to Rick.
Thank you so much. Rick, it'd be lovely to have you for the third conversation.
Terrific. Thanks for inviting me to do this, and I've already learned a lot. I'm looking forward to the Q&A. I'm going to speak for 10 or 12 minutes on a pretty specific topic, which is what effect have the prior Supreme Court and state initiatives on affirmative action had upon actual university behavior. And because I'm an empiricist and I like to sort of nail things down as much as possible, I've prepared some slides, some very low-tech slides in WordPerfect that I'm going to share with you. And I'll walk through these. So as Dennis said, in 1978, the court ruled in Bakke that quotas were not permissible, but that schools could take into account the diversity interest in education. And that was sort of a forerunner to the holistic formulation that Justice O'Connor talked about in Grutter 25 years later. If you read media coverage at the time, you would have seen Bakke as portrayed as a pretty big setback for affirmative action and racial preferences. It did, after all, strike down the system the University of California was using. And, you know, as Dennis said, what sided on the conservatives on most issues. And it sort of sounded like, well, no, you have to get rid of these quotas. And what you could start doing now is give a tiny that, if anything, Bakke kind of legitimated affirmative action and remove some of the doubts about what was legal and what wasn't legal. And the schools found it very easy to sort of use the new language of diversity to achieve goals that were very hard to distinguish from the quotas that many of them had used before. And if you look at the enrollment statistics at medical schools and law schools, what you see is really continuity. You see very, very little change before and after Bakke in the proportions of Blacks admitted, and kind of a slight increase in the proportion of Hispanics admitted. So going down to Grutter, as Dennis mentioned, Gratz was a decision about undergraduate admissions at the University of Michigan, and it said you can't use an explicit point system. Grutter was about the law school at the University of Michigan, and it said, well, yeah, unlike the point system at the undergraduate level, the law school is using this holistic thing where they sort of read the application and think about how race factors into someone's overall qualifications. If you actually looked at what the law school was doing at that time, it really was using something that was essentially, or arguably even more formulaic than what the undergraduate school was doing. In other words, there were very, very clear and systematic preferences given to African-American applicants and Hispanic applicants. And they were very easy to quantify, and they were very consistent. So the justices who pointed out that there really wasn't much real difference between the undergraduate and the law school systems were correct. And an inference from that is that if you required schools to do holistic admissions and not use point systems, that also was not going to be a very effective way of changing school behavior. So once again, when Grutter and Gratz came out, there was a lot of perception in the general public that that this was, you know, on balance, kind of bad for affirmative action, and that we would see retrenchment in racial preferences. I don't know anyone in the university community who believed that. But in 2010, I had tried to do a study of how this had played out within the law school realm, which I know best. And I had gotten data from a lot of public law schools, both before and after the Grutter decision. And so I analyzed them in various ways. And what these numbers represent are kind of quantitative ways of seeing how the application process worked. So this first row here, describing Summers D in admissions decisions, is a way of looking at how mechanical law school admissions decisions were. And the way to think about this number, I think, is that if you just know the LSAT, the undergraduate grades, and the race of an applicant, how well can you predict their admissions? And that's kind of a measure of how mechanical things are. And what you can see from these numbers is that those are all pretty high numbers. They're all between 0.8 and 0.9. And the other thing that's significant is that they go up after Grutter, not down. So as far as we can tell, law school admissions became more mechanical after Grutter than they were beforehand. This second row is just looking at Black applicants. And again, you would see the degree of predictability and mechanical admissions for Black applicants increased as well. This is the preference size measured in LSAT points. This represents more than a 1 standard deviation preference for Black applicants. And that also went up after Grutter. And this is a calculation of the odds ratios, the relative odds of Blacks and whites being admitted. And it's easy to misinterpret this number. For now, let's just think of it as kind of a number that lets us see whether preferences are getting bigger or smaller. And they're pretty unambiguously getting bigger after Grutter. So in all these ways, this Grutter-Gratz duo of decisions had the effect, I think, of strengthening the use of preferences by schools. Kind of ironically, we can look at the undergraduate admissions process at the University of Michigan specifically. And if you look, this is 3 years after Gratz and Grutter, but just before the University of Michigan, before the state of Michigan passed a general ban on preferences. And what you see here, for example, are pretty staggering differences in the probability of admission for people with similar credentials, depending on whether they're Asian American or African American. So University of Michigan was able to do just fine without their point system in achieving their racial goals. So Fisher 1 and 2 came next. And as Dennis said, the upshot of those decisions was really confusion. And it was striking to me as someone who was by that time pretty involved in the affirmative action issue, how much after Fisher 1, there was a move by university leaders to start seriously thinking about race-neutral alternatives. So I think after Fisher 1, really for the first time in this whole 40-year history, you saw university administrators really seeing the writing on the wall and trying to think about ways that they could achieve diversity without the explicit use of race. After Fisher 2 came out in 2016, I saw those discussions pretty much dry up. So I think the net effect of Fisher 1 and 2, again, was not much of anything at all. So that then leaves us with what effect have state bans on affirmative action had? So California led the way in 1996 by passing Prop 209, which prohibited the state and state programs from considering race. And 9 other states followed suit in the 10 to 15 years after that. I'm at University of California, so I've spent a lot of time looking at how Prop 209 has affected the university. And so I want to just show you a couple of slides illustrating those patterns. So let's look at Black enrollment at the 8 UC campuses, for example. Prop 209 was passed in 1996, and it went into effect for undergraduates in 1998. What you see at UC as a whole is the Black enrollment was sort of drifting down from the late 80s into 1997. And the reason for that is that a lot of administrators have become concerned about the really low performance of Black students who are being admitted. The 4-year graduation rate at UCLA, for example, was about 15% for African Americans in the early 1990s. The 6-year graduation rate was something like 40%. So these are terrible, terrible numbers. And a lot of administrators said we need to tighten up and use smaller preferences and not admit as many students who look like they're going to struggle here academically. So the number was already falling before Prop 209 went into effect and fell again about 20% the year that 209 was implemented. But what the university did is it really made a major effort to try to address the pipeline of students to UC campuses. And it created partnerships with local high schools and some of the UC campuses. It increased people's awareness about how to apply to UC. It set up workshops on various campuses for summer school. And the effects of all this was to really broaden the pipeline of students who were UC eligible. And that disproportionately affected low-income students, and a disproportionate number of low-income students were Black and Hispanic. So between 98 and 2006, you saw really big increases in enrollment of Blacks and Hispanics across the UC campuses. You see even bigger increases by the time we get to 2013, but that's a little bit of a different story. So again, in this early period, what we see is with the passage of Prop 209, we have a much smaller mismatch of students at UC campuses. We see many more of the Black and Hispanic underrepresented students going to campuses where their qualifications are similar to those of their classmates. And we see dramatic improvements in four-year bachelor's degrees, four-year graduation rates, six-year graduation rates, and especially something I don't show in this chart is the propensity of students to go into the sciences and do well in the sciences. Blacks and Hispanics have been incredibly underrepresented in STEM fields when preferences were large, I think because they had a lot of trouble competing in those classes. As preferences were ramped down, they went into those fields in much larger numbers and graduated in high numbers. This is a pretty simple chart, just illustrating that over time, after Prop 209, we saw schools finding race-neutral ways to increase Black and Hispanic admissions, and that had perceptible effects at the three elite UC campuses. Okay, so around 2006, you started having a lot of UC campuses come under pressure to reintroduce racial preferences. And there was a particularly striking change at my campus, UCLA, between 2006 and 2007. The chancellor appointed a special commission to review the admissions process, and they adopted at the end of the year a holistic admissions process. And we were able to get data that let us look at how the use of race changed. And I guess this line does a pretty good job of summarizing what we found. It was hard not to see some degree of racial preference even before these reforms were made, but the size of the racial preference roughly doubled and became pretty substantial. And UCLA was kind of a pioneer among the undergraduate campuses in taking this, what I would say is a defiant approach to state law. When nobody sued them, UC presidents started telling the other campuses to follow UCLA's example. So by 2011, most of the schools were using a holistic admission system. And that's why in this earlier chart, you see, I think, this further really high spike in Black and Hispanic enrollment between 2006 and 2013. And that trend has continued to the present. So in other words, in UC, we have a somewhat complicated story. I think there's a period where there's actual compliance with the law and a lot of investment in race-neutral alternatives and a big improvement in outcomes for the Blacks and Hispanics who do go to UC. And then after about 10 years, you see an erosion of that and a reintroduction of racial preferences. And I think that has hurt Black and Hispanic performance, but the school has stopped making data available to anybody who wants to look at those questions. All right, the last thing I'm going to show you is just a little chart I'm actually working on now. It's been harder and harder to get good data from schools on what they do, but we found a way of scraping a website where law students report their admissions outcomes. And we downloaded about 40 or 50,000 reports from law students and systematically analyzed it. And we found that it actually reflected the sort of information we were able to get from public records pretty well. So what this chart is showing is that in schools, law schools in states that don't restrict racial preferences always use them for African-American applicants. They always use them for Hispanics as well, although they're generally about half as large for Hispanics as for Blacks. And the size of these preferences is pretty consistent across schools. You know, the smallest here is Indiana University with 7.1, but an awful lot of the schools are very close to about 10-point preference. Down at the bottom in red, I've got 6 law schools that are in states that have prohibited racial preferences. And there you see all the schools using significant preferences for African Americans, but you see sort of a bifurcation. You've got 2 schools, Michigan and Berkeley, that are basically using preferences as large as any law school does. And then you see other law schools, including my own, that sort of think moderate cheating is a virtue, and so they give preferences, but they're not sort of as blatant and large as conventional law schools do. So the moral here is that legislation banning preferences has not had a dramatic long-term effect. It can have some short-term effects. The court decisions that have sort of restricted practices but stop short of banning preferences have had no effect whatsoever. I think I'm cautiously optimistic that if a broad Supreme Court decision banning preferences might work better, but that's probably something we should explore during the Q&A. So I'll stop there.
Thank you so much, and thank you all so much. Now, I encourage people who are listening, send in your questions. And that will be either to the chat button at the bottom or the Q&A button. I actually, before I get to any question, this is actually cheating a little bit, but Dennis, I know you wanted to say a little bit more, and we have gotten to this portion where you could say a little bit more. Frankly, I'd rather hear what more you had to say than just poke a question immediately, if that's okay. You're still muted.
Unmute yourself, Dennis.
I followed instructions to mute myself while others were talking. Sure, David, thank you. I was just going to note a few additional points about the Harvard and UNC cases in particular. And the Harvard case in particular is most notable because it focuses on the impact of preferences on Asian Americans. And not just on whites. And it makes an explicit argument to overturn Bakke and Grutter and to outlaw preferences by stressing two related things. First, that indeed the burden of preferences now falls not on the white majority, as it did back in the time of Bakke, but on Asians, another historically victimized minority group. And that Bakke and Grutter were founded on a lie, since they held out Harvard's holistic admission system as a model of the acceptable pursuit of diversity, when in fact that very system, stressing quote character, was put in place in the 1920s in an expressly anti-Semitic attempt to exclude Jews, who were then stereotyped in much the same way as Asians are today. And in fact, the Jewish and Asian experience, the experience at Harvard of Asian Americans over the last 40 or so years almost exactly parallels that of Jews in the early 20th century, which is starkly depicted in this chart, which compares Harvard Jewish enrollment from 1908 to 1942 and Asian enrollment from 1976 to 2010. And as the subtitle sums it up, during a roughly equal 35-year period separated by about 75 years, the representation of Jews and Asians climbed steadily, dropped sharply, and then essentially flatlined. A picture is worth 1,000 words. And the evidence in this case showed that Asian enrollment at Harvard would be up to 50% higher if preferences were eliminated. And then along with that, Asian applicants received the lowest scores, lower not just than Blacks and Latinos, but than whites on a vague personal rating measuring attributes like character and kindness, quote unquote, that's assigned by admissions officials in Cambridge who have never met them, even though the local alumni interviewers who do meet with them face to face rate them as highly as other students. And most notably, I want to conclude with this, studies at both Harvard, in this case, and other elite colleges have found that up to 80% of slots awarded to Blacks and Hispanic students under preferential admission admissions come from Asians rather than whites, even though whites are still, of course, the majority of applicants, which I would suggest that in deciding who must give up their seats in the name of racial diversity, admissions officials ironically fall back on implicit prejudice, on subconscious racial stereotypes of Asians as, quote, textureless grinds. So in other words, race-conscious admissions, which was once seen as a tool for combating racial bias, now. So that's my spiel on that.
Thank you so much. And I'm going to go from there to the questions, which have started to pour in more.
Great.
Anonymous attendee asks, Justice Jackson's questions in the oral arguments seem to express a significant concern that a conservative majority opinion might leave colleges unsure of whether they can consider personal essays where applicant race is a dominant factor in overcoming difficulties, quote unquote, in light of the pending decision. Do you believe that she has good reason to worry about that?
No.
To any and all.
I'll look at the transcript, or if you listen to the argument, the plaintiff's lawyers specifically said that would not be the case. They make, I think, almost as clear as day that it's race per se that matters. That if a student talks about race as a factor in their life, and if it's if it's an otherwise persuasive essay, whether it's about overcoming disadvantages from prejudice, or whether it's just about their attachment to their racial culture, that in the same way as someone could write about their attachment to Irish culture, that of course can be considered. It was asked several times during oral argument and answered several times, and I think a lot of people on the other side just won't take yes for an answer, or won't take no for an answer.
Well, so let me suggest a slightly different perspective on that. I think it seems to me it is a genuine issue, in the sense that if the Supreme Court prohibits preferences in a fairly broad opinion, the issue will be what surrogates can universities use. All universities are going to try to find some surrogates, or the vast majority of them are going to. And so the challenge will then be sorting out sort of things that are good faith considerations, which I think are the sort of things Justice Jackson was raising, versus things that are just intended to reverse engineer the court's opinion and still achieve the underlying goal of racial preferences. So it seems to me that what I would like to see the opinion do, and what I think might be the shape of litigation afterwards, is to say that if you want to take into account something that's closely related to race, you need to document that. And instead of using a holistic approach, you need to actually do something like a point system, and allow an evidentiary record to exist that would let challenging plaintiffs separate out the degree to which you're using something as a genuine diversity factor, as a non-racial diversity factor, versus whether you're using it as a surrogate for race. And if you look at Title VI litigation that we have now, that very much exists sort of in reverse. If a employer wants to use a test to make hiring decisions, they've got to sort of quantify what the value of that test is for the ultimate performance of the student. And they got to show that they're applying the test in a way that's not discriminatory. So I think that sort of process could be adapted to the admissions context. But it seems to me it is a real issue.
Yeah, I agree with Rick. So just take a step back. Justice Jackson asked a very long hypothetical about a UNC applicant who, in one hypothetical was white, another hypothetical was black. And the first one says, I'm a fifth generation legacy. And the other hypothetical can't say that because his family faced de jure desegregation prior to that. Thus, that it would have a disparate impact on certain racial groups if the court declared that race can't be used. I didn't find that hypothetical persuasive. I don't know. And so you never know what's going through the other justices' heads. But clearly the advocates for the Students for Fair Admission were unequivocal that you can in a race neutral way say we want to take account of people who have overcome challenges. And so one of those challenges could be that your family faced discrimination, and there's nothing specifically about that that's a proxy for race. Rick is absolutely right that schools are going to try to find ways around whatever the ruling is. So if that's zip codes, then you're going to have a question about whether they are using zip codes in order to achieve race diversity or geographical diversity, for instance, and then you might need to have a record in order to decide that question.
I would just say that, yes, the advocates, SFFA's lawyers at Counsel and McCarthy are well aware, and Ed Bloom, who's the person behind a lot of this litigation, is well aware that there's going to be massive resistance to a Supreme Court decision striking down preferences, and that one way, undoubtedly, will be the potential loophole they opened up at oral argument with that answer. But they consciously opened it up anyway, because to not do so would present even more problems. It would have hurt in this case, and it would just be very problematic to enforce, to say that you can't, the colleges are going to have to ignore, can't take account of somebody writing about their racial experiences or their Irish American or their Jewish American experiences. I think the attitude is, we're aware of the downside of that. We know there's going to be massive resistance based on that, based on a lot of other things, and it's something they're preparing for, and we will cross that bridge when we come to it.
Thank you. I am going to mention first just a comment from George Seaver. There is a foundational statement on this subject in Federalist Paper number 10, the poisoning of faction, that mortal disease that popular governments everywhere have perished. And in fact, I think what you'd be saying is that this current affirmative action regime is importing factional politics wholesale into the very structure of the academic experience, which does not help. But I want to go from actually there to a question, unless if you want to respond to that comment, but I just want to go to the question. Richard White, what evidence is there for the benefit of diversity to the campus experience, to the minority group? Has minority advantage in admissions led to segregation within campuses?
I'll take that again, since that was, as you know, David, that was, I should have added to my bio for you that I did the amicus brief for National Association of Scholars, and that was a big stress in our brief based on the work that NAS has done on neo-segregation on campuses, with separate graduations, separate grading, as I think either Rick or Will mentioned at the beginning, even de facto separate courses. And it ties in to a big spur for that, in addition to just wokeness, has been, I believe, mismatch theory, that when you do match, when you put students all, elevate so many students one or two rungs above institutions where they could do very well and where they would be on par with their classmates, and you put them in an institution where they're academically challenged, where they're below the level of their classmates, it's just inherent that they're going to self-group. And of course, that's further encouraged by the political correctness that now bizarrely encourages neo-segregation. So I think that diversity, as it's been practiced, has actually not had any of these wanted benefits, and in fact has certainly, through mismatch and neo-segregation, has been a real detriment to racial amity on campus.
Yeah, I'll just add that there's a big problem in the research is that one tends to confuse racial diversity with racial diversity achieved through preferences versus racial diversity achieved through outreach or other forms of equal treatment. There have been some studies done by people like Patricia Gurin that have tried to examine empirically what effect diversity has upon learning and things like that. And there are a number of methodological issues, but none of that literature tries to distinguish between situations where you have a diversity of people with similar credentials and a diversity created through preferences. The only scholar I know who has looked at that latter situation, which is generally what is prevailing in elite universities, is Peter Arcidiacono, who was the economist expert for SFFA. And in his pre-Harvard litigation life, he did a lot of path-breaking studies related to sort of preferences and race on campuses. He found that that students tend to sort themselves socially by academic performance on campus. And the result of that was that at Duke, for example, there was more racial segregation among college seniors than there was among college freshmen. Not because people were segregating racially, but because they were segregating academically. And since the academic status was racially disparate, that then produced this side effect of more social distance. So what we really need are cross-sectional studies that kind of carefully look at that, and one can hope that in the wake of the Supreme Court decision, there'll be more interest in doing that. And optimistically, we might think that things will become a little bit less ideological in this space, and there will be sort of more joint searching for what's actually the kind of diversity that works well.
In any other context, if we were to say, we want to exploit your skin color in order to achieve something that's based on your intrinsic viewpoints, in order to reduce, groupthink or achieve better stock trading, we would say that's terrible. We would never equate your skin color with what you think and to say that we can exploit it. But for some reason in this context, that's the argument, is that we have to use that in order to achieve diversity.
Thank you. I'm going to go on to another question, which I actually want to rephrase a little bit, from Gary Van Graff Island. So diversity to me is a phony issue. I believe that Justice Thomas observed that diversity, quote, means everything to everyone, unquote, or words to that effect. Did any justice bother to inquire what the fundamental differences are between groups, e.g. blacks and whites, that justify discrimination based on group membership? Now, I want to rephrase this because frankly, to my knowledge, everybody who's criticizing the current regime, I think, sort of takes as their predicate that there are no fundamental differences between groups that justify discrimination based on group membership. So I would like to rephrase that. Are the defenders of the current regime going towards a defense that is, more and more explicitly one of fundamental differences between groups to justify their discrimination based on group membership? And how should I put this? I would presume if they do it, they're doing it willy-nilly, but are they to what extent are they doing this implicitly or explicitly as they seek to defend the regime?
Well, I think what they're doing is, what we've seen in the last 5 years is the emergence of the argument that systemic racism is a dominant feature of the United States, and that because systemic racism survives even when you have enforcement of civil rights laws, we need to have equity as a goal instead of equality of treatment. I think that's essentially the argument.
Anybody else want to speak to that?
I would agree with that, and I think it translates to an unfortunate yes to the question. Well, nobody, as I recall, no other justice really grappled with that, and of course the defendants like Harvard don't make it explicit, but the whole justification for racial preferences so often reduces embarrassingly to there are inherent group differences, which those of us who still want to cling to Dr. King's belief in judging people by the content of their character just want to resist. But unfortunately, it's maybe it's now we're fighting both the fringe of the far right, the Nick Fuentes group, and we're fighting too much of the modern mainstream liberal opinion, which in effect is arguing for inherent group differences.
Yeah, I thought Justice Kagan asked some interesting hypotheticals, at least on this topic, by saying, are you okay if there's essentially no African Americans in a student, at the highest levels of the Ivy Leagues? Are you okay, given the trends in who goes to college based on regarding sex, whether universities start being 80-90% women? If the school wanted to embrace a preference for males, would that be okay in order to get closer to 50-50? Which I thought was an interesting concession, that there are only two sexes. But the idea that you might have some really surprising consequences, and are you going to feel okay about those consequences? I think that was designed to pull on the heartstrings a little bit and see whether the advocates were willing to defend their position. And they did. They said, look, you can try to use socioeconomic status, you can try to use geographic status, you just can't use skin color and race as the ultimate determiner of who gets the government preference.
I have a follow-up question actually on that systemic racism bit. Is there as yet any judicial precedent for establishing a doctrine of systemic racism within the law of the United States? And what would be the effects if it acquired presidential status?
Well, this is a different topic than racial preferences, but in Washington, the state, not the district, the Supreme Court has recently announced that criminal suspects have more rights if they're not white, in terms of avoiding interaction with the police. And then also that in a trial situation, because of systemic racism, lawyers can't use quote unquote tropes. So to call an African-American litigant combative taints the trial to the point where you have to do it again. So it's surprising to see some of those outcomes. I wouldn't believe them if you just told me about them, but just in the last 6 months, the Washington State Supreme Court has issued both of those rulings. And so it's something that we'll see a lot more, I think, in localities. There isn't a doctrine currently about systemic racism interacting with the Equal Protection Clause in federal court under the Constitution.
Yeah, there's some interesting federalism issues, I imagine. Okay, you're making that sound like this is a going away a little bit. Let me therefore return to questions from the audience. L. Purdy, who has a particular hello to Rick. While the Solicitor General mentioned the purported need for race preferences in the interest of national security, relying on the so-called retired officers amicus filed in Grutter, Gratz, Fisher et al. Was any mention given to the counterbrief by an illustrious group of retired officers opposing the use of race, known as the VFM amicus? And whoever answered this, can you just give enough of a brief explanation of the background for why this matters?
Well, I could partially address it, and let me say hello back to Larry, who was a critical part of the offense in bringing the Gratz and Grutter litigation to the Supreme Court. It was rumored that a key reason why Justice O'Connor unexpectedly ended up endorsing affirmative action in Grutter is that she was influenced by the so-called military brief. And the argument that was raised by retired military officers that the military academies really needed to use racial preferences to ensure that there would be adequate diversity of leadership going into the armed forces, because since a disproportionate share of enlisted men were underrepresented minorities, there'd be big problems in kind of maintaining morale and discipline if the leadership was not racially reflective of that. So, and incidentally, I think I don't think there's much evidence that the mismatch phenomenon is a problem in the military, because you have such total immersion of people in that social structure that I think it operates. I think there's at least a good argument that it operates differently than it does in a university context. Anyway, so it's generally thought that that the concern about military academies and the path to leadership in the military is an argument that gives affirmative action some purchase with conservatives.
Yeah, I don't necessarily view that as a diversity argument. It seems like a national security argument or a morale in the military argument. So I was surprised to hear very little on that point, other than Justice Kavanaugh alluded to the fact that they might consider a carve-out for the military, since most of the issue is about Ivy League and post-secondary education more generally. I didn't hear a mention of the VFM amicus. It was a 5-hour-long argument, though, so I reserve the possibility that it was mentioned in another context.
Same here. I would just note that the Solicitor General did far more than mentioning the purported need. She framed her entire argument around it. Began with that, kept coming back to it, and it was also what she framed much of a brief about, as if this were a case about West Point and Annapolis. And the simple answer is that I don't even think they necessarily have to carve out. They can carve out a footnote saying that, carve out that not ruling that preferences are okay in the military academies, but just this case is not before us, and we don't, nothing in our opinion addresses this specific issue. That's the kind of thing they would do in respect to the Solicitor General's office, but they're not going to decide Harvard and UNC cases based on it.
Thank you. I am going to go to another question, which is from Vicky. Are racial preferences now seen and promoted as a means to effect reparations? Interestingly, this would transfer the benefit to the individual applicant as opposed to the institution. In this framework, racial preferences would no longer have campus diversity as their goal. To any and all.
Well, I think that the litigants in the Harvard and UNC cases, the folks defending the university position, have pretty much stuck to the existing rationales. In other words, they've appealed to the logic of Grutter. I don't think they've generally tried to stake out new types of arguments.
Yeah, I agree with that, Rick. I think the justices were the ones that blurred the lines a little here, talking about many that seemed like redressing previous discrimination, like Dennis alluded to was rejected in Bakke, where they would say things like, how do you account for the fact that African Americans are lower resourced high schools? How do you address systemic racism like slavery or past discrimination in Jim Crow? And of course, the answer to all those questions are, that's not the compelling interest here. The compelling interest is diversity. So theoretically, it shouldn't matter whether we're talking about someone who's descended from slaves or someone who's Hispanic or Native American or someone else who doesn't have a legacy of slavery. And then, of course, Asian Americans, right, who have suffered discrimination in the past under the Chinese Exclusion Act and maybe even systemic exclusion from American society. They're the ones that suffer the most under the diversity regime. So it really is blurring the lines to start talking about redressing discrimination. And I thought it was interesting that the justices were the ones that almost begrudgingly got into the mode of diversity with their questions because they wanted to talk about how society isn't equal for all races.
Yeah, it gets to the irony we've had since Bakke of the whole diversity rationale, that both before and for 45 years since, redressing past discrimination is how we argue about affirmative action. Unless we consciously stop to think, oh no, I have to argue in terms of diversity. And we saw, as Rick points out, as Will pointed out just now, even at the Supreme Court level, the justices fall into doing that, because it is how we argue this issue in terms of policy.
Anybody else want to add to that? Or if not, I will go on to actually a question of my own, I think. Everybody else is encouraged to put in more questions. Does the question of non-citizen beneficiaries of diversity figure in the legal and constitutional arguments? And I'm going to make this explicit. If, for example, Harvard has a majority of its Black applicants, Black admits to Harvard be non-citizens from Africa, the Caribbean, and so on, diversity is being achieved, therefore, with minimal benefit for African Americans. If it is being achieved entirely by, in effect, importing, full tuition paying foreigners to make Harvard be richer, does this serve a compelling interest? Does this satisfy the diversity rationale? Is there a legal and constitutional issue about whether the beneficiaries are citizens or foreign born?
Well, doctrinally, I don't think that issue came up at oral argument or in the case. What was interesting is that Justice Kagan's questions were about whether a school has a compelling interest to create a student body that looks like America. So to the extent that's really what the diversity interest might be getting at, I suppose someone might say, well, if that's what the school were doing, even under Justice Kagan's standard, they wouldn't be doing that, because they would be taking non-citizens who aren't Americans and using that as diversity. So that'd be an additional argument against a school's diversity program, if that's truly what they were doing, is that even acknowledging some interest in creating, different American voices, that they can't achieve that. But that's not an issue that really arose.
So David, if I might jump in, since we're nearing the end of this, I wanted to address one other question.
Yes.
And that is kind of implicit in my remarks was that we should be very pessimistic about the Supreme Court's decisions having an effect. So let me give the optimistic argument, or the optimistic scenario. As I said, when Prop 209 happened in California, there was an initial assumption that schools were going to comply. And most parts of the university did, in reasonably good faith, comply. What I think eroded that is that the elite schools, especially like Berkeley and UCLA, saw themselves losing lots of Black and Hispanics that they had assiduously cultivated, and losing those students to schools that continue to use large preferences. So there was sort of this systematic disadvantage built in, where we were going to, our schools were going to end up less diverse than even race-neutral admissions would produce, because we were competing with a lot of race-conscious institutions. The Harvard-UNC situation creates the potential to surmount that problem, because if you have a national prohibition and it applies to private and public schools, then you'll have a more level playing field. But I think critical to that having its hoped for effect is that there really be assiduous efforts to hold universities accountable during the early years. So I think if a decision comes out next June, then really putting the heat on universities over the next year or two after that decision, and trying to get legislatures to impose transparency, getting, aggressively seeking public records and FOIA information wherever possible, redoubling efforts to point out the counterproductive effects of large preferences. All that is going to be really important because that will be the period during which universities kind of decide, are we going to comply or are we going to cheat?
Yeah, we've seen schools that are abandoning the LSAT, law schools that are abandoning the LSAT and abandoning the U.S. News and World Report rankings, and some schools abandoning the SAT altogether. And of course, that's another way of gerrymandering who your student body is. And as Rick pointed out in his initial remarks, it's hard to figure out sometimes whether those things are driven by race and what they call diversity at the school. So there will be a period where there's going to be a lot of changes and we're going to have to figure out what to do with them legally. Rick, I like your optimistic side. I wish that you could just dwell on that for a second and not be the pessimist.
Yeah. Well, as we saw in UC, if you do invest in the pipeline, if you're creative about it, you can reach people who are genuinely in need. I mean, higher education can definitely do a better job of being a vehicle of mobility, social mobility. So if we can show that that's feasible, that I think is also a powerful argument against sticking with racial preferences that don't work well.
I am going to say, I know this is in some ways that you were thinking of this conclusory, but I would actually therefore I'd like to have an actual 30 seconds to 60 seconds of concluding remarks from each of you, and then I will do my own little wrap up for the webinar as a whole. I guess let's do it in reverse alphabetical order just for fun. Will, would you be so kind as to go first for 60-second concluding remarks?
Yeah, so we at Mountain States Legal Foundation seek out colorblindness in the law. We believe in the foundational principles of the country, the Constitution, and those who framed the 14th Amendment, that your skin color ought not be dependent on how you're treated under the law. And we believe strongly that the government ought not treat people differently. Maybe I'm naive enough to believe what my kindergarten teacher taught me, that it's what is on the inside that counts. So I am hoping and hopeful and optimistic that a positive outcome will come next June, and that there will be no choice for schools around the country to pay attention and heed the message.
Thank you. Rick, I think you're next in reverse alphabetical order.
Well, thanks for having this event. I've learned from it. And I think the National Association of Scholars is going to have a very important role to play during this upcoming period. And I'm glad that you're already jumping into the fray and having this series. And I think anyone who's listening or anyone in the broader NAS community should seek out ways to sort of be part of the organized efforts to follow up on whatever the Supreme Court does.
I would echo that, and on the subject of optimism, pessimism, I'd echo what Will said. Even though I am an inveterate pessimist, I'm optimistic about the decision. Certainly, I think that as most observers, I think SFFA will prevail, and that preferences will be at least largely struck down. On what comes after that, I'm willing to be cautiously optimistic. The plaintiffs and their lawyers know that this decision will not be the end. It will be hopefully the beginning of the end, but there will be massive resistance. But ultimately, I go back to what Will just said. I also believe in what my kindergarten teacher taught me, or maybe a few years later in my life, was when Martin Luther King gave his "I Have a Dream" speech. And as corny as it may sound, I still think that dream will prevail. We got way off track, and I think tragically off track on that for out of the best of intentions. And I think this decision will put us back on track toward that.
Thank you so much. So I'm just going to give a few little concluding remarks, about the webinar and for NAS in general. I guess I want to say The National Association of Scholars was founded in 1987, among other things, to fight for the race-blind university. We have been fighting for that for 35 years, and we will gladly fight for another 35 or another 350 or as long as it's necessary. It's a beautiful dream, a vision. It's a necessary dream, and it's a dream in the highest, which comports with the highest American ideals. That's why we're hosting this webinar. We care so deeply about this, and you have from the beginning and always will. Now, having said that, I just want to say again about the details first. If you want to have further questions, and I think we had answered all the ones that were up, but if more come to you, send them to me, randall@nas.org, randall@nas.org. I will be glad to forward your questions. Again, within 24 hours, this should be up on the National Association of Scholars YouTube channel. Everyone who signed up for this ought to be getting email. Going forward, we have lots of webinars, not just on this subject, although we will be having them, but also, say, American technological history. We're having a webinar on the age of rocketry on December 15th, 1 week from now. But we will be having webinars on race and higher education all through the coming months. I think the next one's not actually till January as we closely approach the holidays. However, check out your NAS emails. They will be advertising to you everything that's following up on this subject. This is only the inaugural one. We're planning on having a whole series of them all the way through to the Supreme Court decision and hopefully beyond. I encourage everyone to become a member of the National Association of Scholars. Go to our webpage, click on a member, a join button. Everybody should join us. We're good folks, and we host things like this. Finally, then, thank you. Thank you to our panelists. Lovely having you. Wonderfully informative. It's the best part of being a moderator is I get to listen and to learn to everybody who's speaking. And I'm sure I speak on behalf of the audience for that too. And thank you to the audience. We do this for you, and we do this with you. I passed on all your questions. Your questions make this happen. So that's a thank you to everybody. The thank you to the panelists and the thank you to the audience. I'm so happy that we could all meet together for this